My name is Erica Cole, and on behalf of the League of Women Voters, I'd like to thank you all for joining us. I'd like to start off by announcing that this event is being recorded. Which I need to do right here.
Recording in progress.
It is being recorded by both WestfordCAT and by the League of Women Voters of Westford. These recordings will be available for viewing after the event on WestfordCAT's website, on YouTube, and on the League's website. The League of Women Voters of Westford welcomes you to this virtual forum to discuss the 70 Boston Road parcel, also known as the former Coldwell Banker building, which has recently been listed for sale. The purpose of our forum is to provide insight into how the property's zoning and legal status would affect a new owner's use of the property. Because of its long history and high visibility at its location, the property is viewed by many as part of the gateway to Westford. That and its proximity to the former Drew Orchard parcel has prompted many to ask questions about the future of this iconic property. The League of Women Voters of Westford is a civic organization that promotes active and informed civic engagement. Consistent with this goal, the League is fortunate that Jeff Morrissette, Westford's Director of Land Use Management, has consented to speak to us tonight to help us all be a little bit more informed about this parcel. But first, some administrivia, if you don't mind. You have all been admitted to this event with your microphones off, and we request that you leave them off for the duration of the event. We will have the opportunity for some Q&A at the end of Mr. Morissette's presentation, but with so many participants, we are planning to use the chat function to air the questions. To support this, I ask that if you do have a question, please post your question to the chat feature, which can be found at the bottom of your screen. Note that you may have to move your mouse in order to view this button. While the chat feature may be used for other words as well, if you do have a question, please begin your post with a big old Q followed by a colon, and that will allow those of us who are monitoring the chat to immediately see which posts are questions. So regarding the main event, the former Coldwell Banker property at 70 Boston Road is being sold. The listed asking price is $1,450,000. The prospect of a turnover in ownership has prompted interest, concern, and rumors among town residents about the future of the building and the land. The League has organized this forum so that we can all learn how the property's zoning and legal status would affect how a new owner, whomever that may be, could use the buildings and the land. Mr. Morrissette will explain the property's zoning status. In other words, what can be done in the zoning district without any variances or special permits from the town. And he'll also discuss any variances and/or special permits which are currently exercised for the property. Mr. Morrissette will also describe the impact that the town's demolition delay bylaw might have on any future owner's ability to demolish the house and/or the barn. As I mentioned earlier, following the presentation, there will be an opportunity for you to ask questions. Mr. Morrissette will start by answering questions that were sent to him prior to tonight, and then he'll take questions that you have entered into the chat. Please know that we will try to get to as many of your questions as possible. We'll end the forum at 8:30. Alrighty then, to our main speaker. Jeff Morrissette has been Westford's Director of Land Use Management since 2018. He joined town staff in 2013 when he was hired as the town planner. Joseph Janowitz is also here. Mr. Janowitz has been Westford's town planner since September of 2021. Thank you both for taking the time to prepare for this forum and for being here tonight. And thank you to all of you for attending our forum and seeking to be informed citizens of our wonderful town. Over to you, Mr. Morrissette. Thank you for being here.
Thank you very much. I'd like to start by thanking the League of Women Voters for extending an invitation and to the Select Board for supporting their request that we can have this conversation tonight regarding 70 Boston Road. So tonight I'd like to cover a variety of topics. I tend to go through them fairly quickly. I've got to go through some Important disclaimers. I'd like to talk specifically about the subject property. I want to define some terms so that we can build on that with later conversations. And then I want to review the Zoning Board of Appeals decisions. There are 4 of them affecting this subject property. And then I'd like to provide an overview of the table of principal use regulations in our zoning bylaw so that you could get an idea of the types of uses that one might expect within the zoning district, which is Residence A. I'm going to briefly touch upon the role of the building commissioner and the applicability of the zoning demolition delay bylaw, and hope to run through all that and answer the questions I received before tonight, all within 30 minutes or less. And then I'll certainly try to answer as many questions as I can from the audience here tonight. All right. So, disclaimers. So tonight's presentation is for informational purposes only. Any opinions I give tonight, they are not considered zoning determinations and they do not bind the town. It is the building commissioner who administers, interprets, and enforces the zoning bylaw. If you want specific legal information about 70 Boston Road or the zoning bylaw, you are encouraged to seek your own counsel. We did not conduct any title examination or boundary survey in preparation for tonight's presentation. And then on the very strong advice of town council, there are certain types of questions that I cannot answer tonight. Specifically, I will not be giving some information about some specific uses that might be permitted at this particular property. To provide that kind of opinion at a public forum like this, even with these disclaimers, has the very real potential to put the town at a very extreme disadvantage in the future. And so I'm not going to do that. And so you may be asking, well, why are we here? Well, I think we can still accomplish an awful lot of good tonight if you give me the chance. And otherwise, I promise you, I wouldn't be wasting your time if I didn't think we can do that. So why don't we get on to the fun stuff, because zoning can be very fun. So why don't we start then with the subject property? And Joe, let's see, here we go. So this actually addresses one of the questions I received before tonight. A lot of people have been asking me, isn't this property commercially zoned? In fact, it is not commercially zoned. It is in the Residence A zoning district. And it's also subject to the Zone 3 Water Resource Protection Overlay District. So, and Joe, I don't know if you can find that plan of land later. We can pull it up later. It appears to contain over about 2.15 acres in total land area, and an undetermined amount of frontage along Boston Road. A little bit of the property is subject to an easement at the very corner, and we can show that on that map later. Let's see. Okay, and Joe, I don't know if you can find, maybe we can get one of those pictures up there instead of the text. Sorry about that, Joe. There we go. The property contains an antique style dwelling structure with portions ranging from 2 stories to 2.5 stories in height. And according to the assessor's property record card, it indicates that portions of the structure have been around since at least the 1880s. I know there may be some other information out there that suggests it's much older, but we're just going by what was readily found in the assessor's information. And then sometime about the mid-1990s, it appears that an addition was constructed to the rear of the building. And the current structure does not appear to meet the front yard setback requirements to Boston Road. That's a good picture. Now, before we go into the decisions affecting the property, and it's kind of interesting, actually, there's a few terms I want to go over so we can have a more meaningful conversation. I want to talk about as of right, special permits, variances, and legally non-conforming uses and structures. So what does as of right mean? Well, it sounds just like it means. It's a permitted use. It's an allowed use to happen. So there may be some non-discretionary permit process required. Like say you get to build a single family dwelling in the Residence A zoning district, you would still need a building permit. You would still need an improved septic design, but through the lens of zoning, it's allowed as of right. And what is a special permit? So a special permit is something that a bylaw can allow for certain types of uses in certain districts. And so, oh, we're already getting questions. And so a special permit granting authority must be designated, and it requires 4 out of 5 votes, a supermajority vote for our boards in town that contain 5 members. And they are said to be discretionary permits because even if an applicant satisfies the criteria for granting a special permit, the board is still not obligated to grant the special permit. And so they're said to have discretion. Special permits are considered to be working with the zoning bylaw because those sorts of uses are thought about, called out, and regulated and given the special permit status as an option. Variances are different. So variances, in layman's terms, you're trying to get permission to do something that is not ordinarily allowed by the zoning bylaw. And so it could be if you want to build a house and you want to put it too close to the lot line, a variance is something that you would need to in order to get that sort of special permission. And it works for structures and uses. And Westford's bylaw is pretty special in that it does allow for use variances in addition to, say, the dimensional variances. And that's a powerful tool. Not every municipality adopts that, but Westford has. And so that will actually turn up in the decisions we see later tonight. Let's see. And then lastly, just briefly, legally non-conforming structures and uses. In simplest terms, those are structures or uses that were lawfully in existence before the town adopted a zoning bylaw, or they were lawfully in existence before there was a zoning amendment that would have made them not permissible. So hopefully that helps. They were there legitimately, and then something came in after a bylaw that made them, they wouldn't have allowed them in the future. So that's the simplest explanation I have for that. So now that we have that background, why don't we jump to, there's actually 4 decisions by the Zoning Board of Appeals affecting this property. That's pretty unique actually in and of itself, that number of variances. So in 1980, Bradford Realty Trust applied for variance relief from the Zoning Board of Appeals. And they asked for permission to have a real estate office use. That's not allowed in the Residence A zoning district. And that is why they had to seek a use variance from the Zoning Board of Appeals. Interestingly enough, the Zoning Board of Appeals did not approve that petition. They voted 3-2 to approve it. And as I mentioned earlier, you need 4 out of 5 votes to approve it. So it failed. It was denied by the Zoning Board of Appeals. However, there are many requirements for timeframes for, especially involving variances and special permits, how long you have to open the hearing, how long you have to make a decision, how long you have to clock in a decision with the office of the town clerk. And so for whatever reason, the denial was not clocked in within the required timeframe. And so the applicant asserted what we commonly refer to these days as constructive approval. So even though they were denied by the Zoning Board of Appeals, they were able to secure a building permit to have the real estate office use go into the barn structure, only the barn structure, not the rest of the building, which at that time, I believe, was a 2-family dwelling. So after the first iteration in 1980, you have the barn being occupied by a real estate office, and the remainder appeared to be a 2-family dwelling. So then you fast forward to 1992, and the Zoning Board of Appeals granted additional variance relief. I never really granted it the first time, but they were in. And so now they asked for permission to expand from not just the barn, but to the remainder of the structure. And so they got permission. The zoning board decided, you know what, rather than having multiple uses out there, let's just have one use. And so the entire building at that time got to be used for the real estate office use with some limitations. And so if you fast forward a little more, in 1993, not that long after that, the Zoning Board of Appeals granted additional variance relief. And so they got permission to construct an addition to the rear of the building. That's the one that happened in the mid-1990s. And for a like expansion to allow the commercial real estate office use to go into that addition. There was a limitation imposed as well at the second floor, the upstairs of that main building. It was to be used for dead storage space only. So they couldn't have an active office use in that top floor. And so then finally in 2004, they were petitioned again and the Zoning Board of Appeals granted further variance relief. And that was to allow for the second floor to also be used for some office use. There were still some limitations, but they were no longer limited to just the dead storage office space. That's kind of interesting. 4 decisions, and that's how you got to where we were. And I think that pretty much carried us forward until, Coldwell Realty vacated that space a short time ago. So that's how that use was allowed in there. So to the question, it was not commercially zoned. It was only there through benefit of use variances that the real estate office was able to go in there. And so that brings us to the modern day in terms of the zoning decisions. So Joe, if you want to move on. So now, since I'm not really allowed to talk about specific uses at that specific property, what we're going to do now is talk a little bit about our table of principal use regulations. And that way, I think this will give you a very good understanding of what might be allowed in a lot that's in the Residence A zoning district, okay? So, and we can go to Appendix A. Actually, Joe, do you want to maybe jump to that now? Thank you. All right, so we did a little color coding here. So you notice that we're going to the column that says RA for Residence A. That's that zoning district that 70 Boston Road is located in. And so you'll notice the Ys are colored green. So those are the uses that we talked about that would be the Y is for a yes or permitted or as of right. And then we didn't bother coloring the Ns, which are no's or they are prohibited uses in that zoning district. And then you'll see that we have SPA and SPB, and they are color coded yellow for SPA and sort of a pinkish for SPB. So that means a special permit would be required in order to have that use in that zoning district. And the A denotes the Zoning Board of Appeals and the B denotes the Planning Board. So that is who the special permit granting authority would be. So as you move through this, a lot of it isn't surprising. If you want to go back, I'm sorry, Joe. So as you would expect a single family dwelling, it's allowed in the Residence A zoning district. So too is a lot of religious structures, some agriculture, childcare facilities. And so you would expect those things that are Ys and in green, as long as they meet certain requirements, that you would expect that they would be allowed through the lens of zoning that we talked about. Sometimes there's other restrictions, say if you're in proximity to, say, a wetland resource area, or say there's some other restrictions affecting the property, or say the soils are unsuitable for septic system. Those are all things that could be deal breakers that don't have anything to do with zoning. So in this case, let's look at, say, conversion of a dwelling, number 2. Conversion of a dwelling is where you have a single family dwelling that predated the town's adoption of a zoning bylaw, which was 1955. This could allow, on a case-by-case basis, an applicant to convert a single family dwelling to up to 4 dwelling units with a special permit from the Zoning Board of Appeals. So hopefully that gives you a sense of how that would work. And we know that a special permit has to be a special permit granting authority, supermajority vote. And we know because it's a special permit, the board has a lot of discretion to say yes, and they have a lot of discretion to say no. And any use that is listed in the Residence A zoning district that is in the N that is prohibited, you would expect that they would need a use variance in order to be able to do that use there. Okay, variance. So let's see. All right, Joe, if you want to jump. All right, let's actually dive a little deeper into the approvals at 70 Boston Road. So since they have a use variance allowing a real estate office, you might expect that another real estate office could easily go in there if there's a new buyer and they want to put in a real estate office. Well, that's certainly possible, but it's not a guarantee. So let's remember, the real estate office that was in place, say in the last year, those weren't permissible under the first, the second, or the third zoning decisions. It was only made possible by the 4th zoning board decision. So with any decision, You can think of it as you talk about at town meeting, there's the four corners of the decision. So whatever use is going in would have to fit neatly with what the Zoning Board of Appeals approved. And sometimes there are conditions, restrictions, that sort of thing. So you can't just say any old real estate office can go in there, because we know from this very example, that isn't always the case. And to make things even more complicated, real estate office is not a defined use in our zoning bylaw. So actually, it's easier for me to just read this off, Joe. So that falls under the category of business or professional office, and it lists miscellaneous professional and business offices and services, including but not limited to banks, financial agencies, medical, legal, accounting, and other professional services, real estate, and insurance offices. So the Zoning Board of Appeals decision granted approval for a real estate office, but that's not a defined use in our bylaw. So it would be interesting if someone in the future came in and wanted to know if they could, say, have an insurance office in that building, because that's the same use category, the defined use that's in our zoning bylaw. That's not exactly what the decision says. So that brings us to one of the roles of the building commissioner. It's the building commissioner who would take a look at a specific proposed use and make a determination as to whether it's allowed or if additional relief, such as special permit or variance relief, would be required. And I honestly don't know what the building commissioner would say in this case. I'm not going to ask him, and we're never going to know unless and until we have a specific application that makes him answer that question. So this, I think, just goes to show you how nuanced this can be. It's not an automatic yes, and it's not an automatic no. So that is one of the reasons for the building commissioner, who is charged with administering, interpreting, and enforcing the zoning bylaw. And he does not have an easy job, and it's often thankless. So let's quickly talk about the applicability of the demolition delay bylaw. And Joe, I don't know if you can find that and bring that up. So this is in our general bylaws. And essentially what it says, if you have a structure that is, I believe it's a rolling 85 years of age or older, if someone files a request to demolish the building commissioner then sends that information, that permit, to the historical commission. And they have a certain amount of time to evaluate that and make a determination as to whether or not the structure has any historical significance. If they determine that it does not, then they can proceed with the demolition permit, along with all the other customary reviews. If they determine that it does have historical significance, they can delay the demolition permit for up to 6 months as they try to pursue other options and remedies to see if there's ways to preserve it or find alternate solutions. And there's some, I don't know if you can make that a little larger, Joe. Maybe not. So needless to say, if it's deemed historically significant, there is a time period and a process that they can try to preserve in some manner the value that they've determined to exist. So this structure, the vast majority of this structure, is certainly old enough to qualify, and so it would be subject to the demolition delay bylaw. Technically, the more recent addition at the back of the building might not be, but it would be practically, it wouldn't make sense to separate that and demolish that I can see. So hopefully that gives some of you folks some peace of mind, and that there would be a review process and potentially some delay to give the historical commission a chance to save what they can. So I think that might bring us, that was a quick overview. That might bring us to some of the questions that I received prior to tonight's meeting. So one of the questions that I received is, if the building stays vacant for 2 or more years, would the real estate office or the permissions for the real estate office go away? And so what I will carefully say to that is, I think that individual was assuming that it was a pre-existing or lawfully existing non-conforming use. So if it was a pre-existing non-conforming use, the zoning act says if 2 years or more go by and the use ceases, you lose the protective status of it being a lawfully pre-existing use. And so that does not apply in this case because that use is there with benefit of a variance and it's not a pre-existing non-conforming use. So that would not apply. And so variances typically, unless specified otherwise in the decision, variances travel with the land. And so mere time does not necessarily extinguish a variance. And that's a whole other topic, but the 2 years in this case, in my opinion, would not apply. That applies to the non-conforming uses, not a use granted through a variance. Another question that I received tonight. Let's see, conversion of a dwelling, actually. This is a good question. So one person was asking conversion of a dwelling, it applies to a single family dwelling. And the existing building is not being used as a single family dwelling. And prior to the real estate office going into the building, it was a 2-family. And so they wondered if conversion of a dwelling was even a possibility. That's a good question. What I will say is that I do not believe that the town should be robbed automatically of an opportunity to preserve some of its historic or rural character. And if at any time before the town adopted its zoning bylaw in 1955, if it was a single family dwelling, then I think both the building commissioner and the zoning board of appeals in particular, I think they would have a great deal of discretion in deciding whether or not to grant a special permit to allow for the conversion. Probably more than I should have said, but I'll leave it with that. And then I had some questions about the abutting properties. So Joe, I don't know if you can maybe find one of the maps that shows the assessor maps where it might have the parcel IDs on it. And while Joe is trying to pull that up, I believe there are 3 parcels abutting this and another parcel in proximity to that. 3 of those 4 parcels are controlled by the select board, actually. And there's a 4th parcel, actually, as you get to the exit ramp, that one is actually controlled in the care and custody of the Conservation Commission. So Joe, let's see. So if you, so if you want to go to one of the parcel just below that, that one appears to be in the care and custody of the Conservation Commission, and the one behind the subject property, and the narrow parcel. And if you go up one to the right, that one, they all appear to be in the care, not the large one, not that one. They all appear to be controlled by the select board. So perhaps some of you folks will be put at ease a little bit by knowing that the immediately abutting parcels are controlled by some arm of the town of Westford. Let's see, those were, I think, the questions that I received before tonight's meeting. And if I'm missing something, I apologize, but if folks could type them in, that would be great. So
Thank you so much. We did have a couple of questions. The first one was early on, as you noted in your presentation, asking why the amount of frontage, lot frontage, is undetermined. So I'll start to try to answer that. Joe, if you can, our town engineer sent us, I think, a 75% design plan for Boston Road improvements. If you could try to hunt for that while I try to answer this question. So that wasn't laziness, I assure you. We have a plan of land that shows some math on it. But in this case, pretend you own a lot of land in Westford, and
pretend that your lot abuts or touches the right-of-way with Route 495. So you wouldn't expect that you could put your driveway from your house onto the pavement of Interstate 495. Not only that be insanely dangerous, but it's not allowed. And so with many rights of way, even though it's public, state, there's something called it's no access. And so no access means there should be zero expectation. You're not allowed to say have a driveway, have some other form of access going through that line. Only the state can do that. And so whenever you are nearby, say an exit ramp or an on-ramp, it is very common that they have no access extended for a period of time, because they do not want to have an unsafe situation where you have a driveway right at the end of an exit ramp and you have all these turning movement and conflicts. So there's probably some, can you drag it a little more? Maybe there's, let's see. Oh yeah, sorry. So Joe, yeah, right there. So it says no access. See where it says 1959 State Highway Layout? Right there, it says no access. So wherever that limitation to the no access is, that would not qualify as practical frontage, because frontage in our zoning bylaw is meant to provide practical access from, say, your lot to the public way. So that type of frontage would be considered illusory or impractical, and you can't use it. So that's why we did not put a value there. Probably more than you wanted to know, but I don't see a dimension easily called out that calls that out. So, but that is why it's no access.
All right. We do have a couple more questions. Janella Delmar has two questions, actually. She asks if you could expand upon when variances from the past stay or don't stay with the property when it is sold. I know you did go into that a bit, but she's hoping for more clarification.
Okay, no, that's a great question. So in general, variances travel with the land, and usually ownership, change in ownership usually does not affect that. If there is an explicit condition of approval that says a variance terminates upon change of ownership or for a certain time period, that would obviously trump the generality. But in general, and I did not see that in the zoning board decisions, a change of ownership would not remove the variance from the property. It usually has to take some specific act to nullify a variance. It doesn't easily go away.
Okay, hopefully that answers. And there's also a question as to who does own that large parcel that is behind 70 Boston Road.
So I believe that is in the care and custody. I think it's could be Windmere 2 subdivision. It may be some land associated with that, but if you give me 1 second.
What parcel?
So it appears that it is owned by Windmere 2 Trust. I think Windmere was the name of perhaps some of the larger of a subdivision around there. I don't know if there are some folks out there that have that history, but it is not owned by the town. Thank you, Joe.
Okay, good to know. We have a question asking, do these same requirements in references to variances and special permits apply if the town were to buy the property?
So like I said, the variances travel with the land. However, municipalities enjoy a special privilege in that municipal use is generally allowed in all zoning districts. So Joe, I don't know if we can go back to Appendix A. So under principal use, a municipal facility is allowed in all zoning districts. So municipalities enjoy some favoritism, at least in our zoning bylaw. We apparently gave ourselves that benefit. So it's ironic, an office building is viewed differently than, say, if it were municipal offices. One is municipal and one would be commercial. So I don't know if that helps. Yep. Thanks, Joe.
Yeah, wow. It's a lot of whys.
Yeah.
Yeah.
Doesn't mean there isn't a permitting process. It just means that, it's an allowed use.
Great. All right, we have another question. In regards to the surrounding lots being controlled by the select board, are those lots associated with this property in some way? And are they or this lot part of the farm preservation that restricted the neighboring lot recently?
So to the best of my knowledge, the 4 lots that we talked about surrounding 70 Boston Road that are controlled by the select board and or the Conservation Commission, they are not subject to the agricultural preservation restrictions. I did not do a detailed research of those properties as they weren't the true subject property, but I did not discover any of those kinds of restrictions in a quick cursory review. It is different land than the Drew Gardens property. It's entirely different.
Absolutely. The next question is a question as to whether this property can be developed for town offices, and it does sound as if that's possible.
So what I will say, in the Residence A zoning district, municipal use is allowed throughout. That does not mean, again, you may still need, obviously, town will, budget, and there would still be permitting processes. But municipal use is allowed in all zoning districts.
Thank you. There's a request that you please show the variance details once again, now that we understand the importance of that.
Joe, I don't know if you can go to the most recent variance.
And while you're getting that up, Denali had a follow-on asking if existing parcels variances are for real estate offices only, any other use would require additional variances. Just a clarification on what you were saying.
So again, I can't answer that question definitively. That would be when if the building commissioner gets a specific proposal, he would review it and have to make a determination as to whether some sort of relief, special permit or variance would be required. And as I mentioned, let's see. Yeah, I think that's the most recent. Thank you, Joe. I want to scroll through that a little bit. So yep. So I can't answer how the building commissioner would look at it. We gave one little example of the insurance office and a real estate office. So the only relief that's on the table right now is it says real estate office, but as I mentioned, that is not a defined use in our zoning bylaw. And so there's some lack of clarity as to what the building commissioner might do, and he won't make such a decision until he has a specific detailed proposal before him.
That makes sense. I'm not sure I understand exactly what this is in reference to, but Heidi Tierney asks if there is a Boston Road construction project happening that may affect this property frontage.
So Joe, if you could try to dig up that 75% plan again. So it's certainly possible there, with the Boston Road improvement, that obviously has the possibility to impact a parcel. There could be some takings. Sometimes they're temporary takings for the construction process, but we'll see if there's anything obvious to us on the 75% design plan. I would expect some temporary takings at the very least. I don't know if you can, let's see. All right, so it looks at a minimum that there appears to be some temporary easements proposed. I'm not certain how much of the frontage so if we can't get you a clear answer tonight, it does look like there's at least some easements, some of which are temporary, some of which may not be. I can't say with certainty. It looks like there's at a minimum temporary easements. And what we can do is we can certainly follow up with and of course, these are 75% design plans. So this could all be subject to change, but I'm not seeing anything that jumps out at me, but we can check with our engineering department and we can certainly follow up with you folks and get you an answer. But usually I will say, if there is some sort of taking that affects the property, usually the owner is not penalized for a public acquisition or taking. So I don't know if that helps.
Ideally not. Thank you. We are getting down to some of the last question. The last question is a request for these slides to be made available. Do you have any concerns with these slides being made publicly available?
That's totally fine. We're happy to share them.
Fantastic. So our web manager for the league, unfortunately, is unavailable at this particular time, but we will make a point of providing at least a link at some point in the near future on the website, and ideally the charts themselves.
Okay, great.
All right. We are getting to the bottom of the list of questions. Are there any more questions that folks would like to put into the chat? We'll give you a few seconds for typing.
Very welcome.
I do not see any further questions. Thank you both so much. It has been a wonderful opportunity for us to learn more about this parcel, and we do appreciate your putting in the effort not only to spend time with us tonight, but to prepare and work with legal, etc. We value you. Thank you so much.
Great. It's our pleasure. Thank you very much for the opportunity. We appreciate it.
Thanks, Jeff.
All right, and that is it. Thank you all very much for coming. And this is the league's website for any information on future events. And hopefully we will see you again soon.
Thank you.
Thank you.
Thank you.
Record.